Hello, my true crime lovelies. How are you? I'm at work. Well, I'm in the office. I'm not working at this moment. I'm going to go get Sugar Bear. But listen, I am not going to bury the lead. The state has responded, and basically, they told Sarah to pound sand. So the first motion that I'm going to go over with you is the response, or it's a response to the motion. So the state is like, this whole battered wife spouse business. All right, let's get into it. Oh my goodness. I'm like, say what now? Come through, Cacciatore. All right. I don't know why I'm this excited, but it's BS. It's BS. Okay. State's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome, and state's motion in limine, and state's motion for examination by state expert. So they put three responses all in one. They're like, we're not going to piecemeal it together. No, no, and no. Comes now, the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. On September 6, 2024, the defendant filed a notice of intent to rely on the defense of battered spouse syndrome. So just laying out the facts. The Florida Rule of Criminal Procedure 3.201B requires the defendant to include a statement of particulars showing the nature of the defense the defendant expects to prove. Then there's a little ellipse because there's more to the sentence that they're not going to quote here. The defendant's notice does not include any particular facts, which, if produced at trial, would allow for Dr. Julie Harper to opine that the defendant suffered from battered spouse syndrome. Therefore, the defendant's notice is legally insufficient, and the court should strike the notice. Furthermore, the defendant only lists Dr. Julie Harper as a witness to show the defendant suffered from battered spouse syndrome. An expert witness cannot be used as a conduit to introduce inadmissible hearsay evidence, such as the defendant offering the defendant's hearsay statements. Somebody should have told that attorney. Remember in the Depp v. Heard trial, the one attorney, everything Amber said, she was entering it on the record. It was all hearsay. It was all hearsay. All that, like, anyway, clearly some people can try and get away with it, but state of Florida is like, no, ma'am. Mm-mm. Florida Statute 90.704. Therefore, the defendant should be precluded from mentioning battered spouse syndrome in her opening statement, and Dr. Julie Harper should be precluded from testifying until the defendant testifies to underlying facts that would allow for her expert's testimony. Medina v. State. And that was, oh God, what year was it? 1990. It went to appeal. Right, I can't remember. This is something to do with the appeal court, the appeals or appellate court. Oh my God, I'm getting too excited. Sorry. The defendant has previously provided statements to law enforcement. Therein, she claimed she accidentally left the victim in the suitcase overnight. Battered spouse syndrome testimony is not admissible if her defense is that killing the victim was an accident. Wagner v. State, 240 SO, again, another thing that went to the appellate court. The defendant should be precluded from mentioning battered spouse syndrome in her opening statement, and Dr. Julie Harper should be precluded from testifying until the defendant has presented evidence of a justifiable use of deadly force. Finally, the state requests the defendant be ordered to submit to an examination by an expert of the state's choosing, Dilbert v. State. So that's with both sides, right? If you present something from your expert, the other side has the option to present something from their expert that will either corroborate, support. More than likely, they're going to find an expert that disagrees or provides an alternative way to get to the same conclusion or to get to a different conclusion. So this was filed by Mr. J. I thought it was by Cacciatore. So it was sent to James Owens and also Mr. Kevin T. Beck. So they are on notice all in one. But wait, there's more. They were on Pound Sand, ma'am. So this also filed today. Notice of provision of discovery comes now. The state of Florida by and through the undersigned assistant state attorney and gives notice that the below listed exhibits have been disclosed to James Owen and Kevin T. Becks as follows. The following have been sent electronically on September 11th, 2024. Previous depositions transcripts. Oh, it's September 11th. Hopefully, you guys have had a moment of silence today, but I do just want to verbally acknowledge those who lost their lives in the terrorist attack on September 11th. And if you lost someone that you loved, thoughts and prayers and good vibrations sent out to you. That, yeah, just want to say that. Just want to be mindful of what's going on in the world besides the drama of Sarah Boone. I certify that a copy hereof has been furnished to James Sylvan Owens and Kevin T. Beck, and this was filed by Mr. Cacciatore. Okay, now we go to, oh, I should check to make sure you guys are seeing these changes. Okay, yes, you are. Notice of provision of state's amended witness list. Comes now the state of Florida by and through the undersigned assistant state attorney and files this notice of provision of amended witness list, certifying that on the date of filing the instant notice of provision of amended witness list, the undersigned assistant state attorney electronically served upon the defendant an amended list of names and addresses of persons known to the state of Florida to have information that may be relevant to any offense, charged or any defense thereto, or to any similar fact evidence to be presented at trial under section 90.404 paren 2 Florida statutes that were discovered subsequent to compliance with rule 3.220 paren b paren I paren or not I, A, oh my God, B1A, all in separate parens. So on the date of filing, the instance of this version, did they put the witness list in here? No, it doesn't look like it. Okay, that's might be under seal. Although it's not marked on the docket, but and this one was filed yesterday. Okay, so how about I close them as I go along so I don't get myself confused? Okay. State's response to defendants, uh-oh, little typo. Come on, state, get it together. To defendant's second motion for additional discovery comes now, the state of Florida by and through this undersigned ASA and stats. I think they mean states. They were mad in there trying to get this out. And states as follows. The state filed its response to notice of discovery on March 20th, 2020. Say what? March 2020. And we are in what? September 2024? They are like Owens. And what was the other guy's name? I can't remember. Get it together. Paragraph 5 of that pleading outlines the controlling law on this issue. State v. Wright holds that the court must first inquire whether the information the defendant seeks is available if she would exercise her due diligence, i.e., don't be lazy and bothering us with these questions when this is something that you could have looked up and found with minimal effort on your part. Like, don't use this as an excuse and come bother us. If the defendant were to exercise due diligence, she could easily obtain the information from the Orange County Sheriff's Office. And this is true because they gave it to me in an email. The trial court should have first ascertained whether defendants could have obtained the requested criminal records from other sources through due diligence and determined whether the defendant The defendants, shout out to Susan Opper, had exerted their own efforts and resources and exhausted other available means to procure the information. They're citing State v. Clooney, 1973. If the defendant has attempted to obtain these records through the means available to her and failed, she has failed to state that in this motion. So we don't know nothing about it if that happens. So don't come back with that response because you didn't tell us. Therefore, the defendant's demand for supplemental discovery should be denied. Certify. This has been furnished to James and Kevin. There we go. Oh, it's like Kevin James. That's how I'll remember that. You guys know from King of Queens, right? Or is it just me? Okay. I think I did this one. Yeah, we did that one. You can't see what I'm looking at. I just wanna So there's one more. It's kind of repetitive, but James Owens asked for supplemental discovery and like additional discovery. What was his other request? Addition, yeah, one was additional, one was supplemental. So there again, let me make sure you guys can see that. Yeah, okay. Comes now the state of Florida by and through this undersigned assistant state attorney and states as follows. The state filed its response to notice of discovery, so it's basically saying the same thing. Um, Therefore, the defendant's demand for supplemental discovery should be denied. This was sent on the 8th. The other one was sent on the 10th. So the other request to deny it. Say what now? What do you guys think? Like, what do you guys think? The state is having none of it. I wondered, I mean, I assume they would be able to submit for denial. I thought they would cite more case law, but perhaps, there's a definitive, like, this is it. These are what the rules say. And yeah, the whole Julie Harper thing, I'm going to do a video on that once I'm with Sugar Bear. So just be warned if you watch that one, there will be a baby and dogs in there. But I have the visitation logs of when she sent her, and I think she spent, like, maybe it's either 6 or 8 hours, I can't remember, and I left my notes over at my desk, that she spent with her, and why, if whatever Sarah disclosed, why didn't Padilla try that, right? Because she started seeing Sarah, being Julie Harper, started seeing Sarah when Padilla was her attorney. So all of it seems a little fabricated, but again, there's nothing in there. Well, I shouldn't say fabricated. What is the word I should use? Maybe overly constructed, maybe thinly constructed, thinly veiled attempt at subverting the law. Anyway, how was she in imminent danger? No, at no point in time did she tell the detectives in her long interrogation video that she was in imminent danger. She actually portrayed the opposite. They were having a great day. It was nobody was out of sorts. It was a good day. We were coloring and doing childish things all day, and we had a bottle of wine, and it was all good. So that's gonna be hard, and obviously, I mean, listen, the defense attorney has to zealously represent her. I get it, I'm not begrudging that, but, like, make it make sense, right? I'm telling you, it would be a better explanation if it was a BDSM game gone wrong, like, right? She's the do they still say master? The dominant one? Let's be politically correct. She's the dominant one, he's a submissive. He was put in there as a game, he didn't say his safe word. That would be a better excuse than she was afraid for her life. When you listen to that video, I'm not saying that that's what they were doing, but, like, what he's alleging now doesn't make any sense. So we'll see. But, I believe because the motion, like, all 3 were in one motion asking the judge to strike the defense of a battered spouse, I believe the state gets to at least get their own expert to interview her before the judge can strike it. I mean, he may strike it outward, like, just on its face because they didn't provide the particulars, right? Or he may say, "I'll give you more time." You did mention in court the other day that it was short notice. I'll give you more time to define the particulars. And while you do that, the state will be having a therapist, psychiatrist, expert, whomever interview Sarah and see if they can come to that same conclusion, right? The problem is Sarah thought she could talk herself out of it, not realizing she talked herself all the way into it because they were having a good day. People are passing by. I'm in a conference room, but they were having a good day. It was a good day. Roll ice cubes. Today was a good day. Oh, not that music, because that's a little rough around the edges for Sarah. She likes to sit in silence. Who believes that? Okay, let me get out here. I'll talk to you guys later. Toodles. Thanks for hanging out with me. If you made it this far, I appreciate you. And, maybe hit that subscribe button, hit that like button, help your girl out, grow the channel. Bye.